I'll meet you then. What up, everybody? Unmute yourself when you're ready. I put you on mute. Just unmute yourself.
I'm ready. I just.
There you go.
So I'm actually kind of mad.
Uh-oh.
Because I thought I sent you the new. Go to the room, please. So I thought I sent you the updated misdemeanors or felonies. The new. I could have swore I sent that.
No, you asked me that I get it. I said no.
I could have swore I did. I only sent you the actual assault and battery outline.
Yeah.
I'm mad because I made another like 8 or 9 misdemeanor felonies that we were going to do, and then we were going to jump into this. So it's fine. I'm kind of mad because I really was excited for those misdemeanors versus felonies.
The main thing, as long as you know what you want to do. I'm just here for the ride, bro.
Well, I'm fine. I think not doing the misdemeanor or felony, I think is fine. It just means that I get to really dig into assault and battery, which is cool. I'm excited for that because it was truly fun preparing this. So I think this was fun. I'm gonna be honest. This was fun doing it. So we're gonna do it step by step. And before we go into it, I'll warm it all up. So I'll do the regular shtick.
Just
first thing first, why is your camera off? Why is your camera off?
I was moving some stuff. I'm about to turn on. I'm just moving stuff, that's all. And then some paperwork. But just so you know, there's only one person here so far. I don't know if you want to jump into it yet or if you want to wait a little bit.
Well, we could wait a little bit. I'm gonna just we can wait a little bit.
Oh, there's the 2. Oh boy, my back and ribs hurt. I think I messed myself up working out. I didn't stretch my back. No.
Well, how was your day, man?
It was good.
No, good.
Good enough. No, I don't like it. I don't like it.
Say again?
I don't like this chain. It's too small now. I don't even look like the whole guy no more for this. Next time I'm just gonna come looking like a student.
You gonna watch it in the other room, girls? Yeah, they are. Okay. All right, man.
Kicked it. Went to
Say
lunch.
Again?
So it was good. Just kicked it. Went to lunch. Did some, I guess, preparation for some.
That's good. I'm gonna email when I get back to the office. I'll email you the new group of misdemeanor felonies because I'm mad because I really had fun in doing that. That was cool. I would write it down, the statute, and how some of them can actually be modified. It was cool. It was fun. It was fun. But on that note, I'm just gonna take care of the big introductory things. Hey everyone! First and foremost. Hey everyone! First and foremost. I want to say thank you. I do appreciate this opportunity, Warlord. I love teaching. I love the law. Ultimately the goal in this is to become a professor one day. So I really do appreciate the opportunity. I'm fine-tuning my skills. First and foremost, that I wanted to get that out of the way. Next, is for educational purposes only. We're going to go from general to particular. We're going to go general concepts, common law, to specific statutory concerns as it concerns, the Commonwealth of Virginia. In addition, I am licensed to practice law in the beautiful Commonwealth of Virginia, no other place. So I want to say that first and foremost. I don't want this to be misinterpreted or misconstrued as to being anything more than for educational purposes only. In addition, I am in no way trying to solicit my services to anyone. I am not trying to establish an attorney-client relationship with anyone. I got 3 kids and a wife. I'm not trying to lose my job. This is strictly for fun. This is for me to have a better grasp and understanding on the law that I truly care a lot about, and as an opportunity for my friend and I to kind of grow as people, as law-abiding citizens. So please take it solely as that. And if you do have any questions or comments as it pertains to laws in your state, look them up yourself, or reach out to an attorney in your state. Um, having that being said, say again, Warlord.
I was just saying, or they can call me.
Or they could call
I
Warlord.
can.
That is true. He knows
Yeah,
all, and that is
I can
a
help.
safe approach as well.
Right, I can
So,
help somebody catch a little fade, or if they trip, they can get the whip spray.
well, it's funny that you bring up people catching fades and getting their whips sprayed, because
Mm-hmm.
today is assault and battery. It's a fun. It's honestly a fun law. It's awesome. One of my biggest cases. One of my biggest. That's a lie. One of my first cases that I won was actually on assault and battery. So we're going to go over, and I kind of have a brief outline of what we're going to go over. I'm going to go over the concept generally. I'm going to go over the elements. I'm going to go over some factual patterns or scenarios where those elements would be satisfied. I'm going to go over others where they weren't necessarily, and kind of as to why the court believed that was the case. I'm going to go over very common defenses. Some defenses in particular, I'm going to go over self-defense. The imperfect self-defense, which I'm going to go into as to why it is imperfect. Defense of personal property, defense of real property. We're going to talk about that, Warlord, because that's big. Defense of others, provocation. This is also a big one. And then one of my favorite defenses, I just love trying to make it mutual combat. It's always a good one. Mitigation. So,
a lot lately.
huh?
I've been hearing that term used a lot lately.
It's an interesting concept. I will say when we get into it, it's one that is used, I think, incorrectly at times. And I do think that it is used kind of as a way to try to minimize if someone was an instigator or a provocateur. But I do think that I mean, I have used it effectively. So we'll go into that. We'll go into, units of prosecution, arrests, and if it's conducted in the presence of a law enforcement officer, and other relevant statutes. So statutes that can be used if we want to try to get it amended to a lesser charge. So, so please, if you have any questions, by all means, chime in, leave a comment. Warlord, you can interrupt me at any point. So elements of assault. So there's 3 elements, generally speaking, that need to be proven in order for an individual to be convicted of assault and battery. Warlord, assault and battery, is it a misdemeanor or felony?
I thought that depends on what it is. Like, I guess we'll go with the felony.
So, yes and no. If it is a law enforcement officer, assault and battery on an LEO, it is a felony. I want to say felony 5. If it is just assault and battery, generally speaking, it's a misdemeanor 1, which means punishable up to 12 months or $2,500 or both. So that's one of those fun ones. Actually, I'm going to try to call my shot. I do think I'm right. I think it is felony 5. I want to say this. Come on, fingers crossed, big bucks, no whammies. Felony 6. 1 to 6. All right, yeah. So now, engage in an overt act is element 1. Intending to inflict bodily harm and has the present ability to inflict bodily harm. Those are the 3 elements. Now, or there's 2 groups of elements. It is engages in an overt act intended to inflict bodily harm and has the present ability to inflict bodily harm, or engages in an overt act, intends to place the victim in fear or apprehension of bodily harm, and creates such reasonable fear or apprehension in the victim. So, from those 2, we kind of see really the overlay, right? We see, okay, in one, there is the intending to inflict bodily harm and having the ability, and then there's the intending to place the victim in fear, apprehension of bodily harm, and then creating such fear. So from those, we kind of get two things, Warlord, if you're catching it. In one, you're getting actual physical contact or harm, and you're having the ability to do it. So actual hitting, right? The other one, you actually have instances where you don't need to hit people. It's not required for you to actually make harmful or offensive contact with another. Just trying to place them in fear of that harmful or offensive contact and them being in fear is enough. So I kind of like putting that out there in the forefront. I like to say that up front because the thing that always worries me is that when people talk about assault and battery, they do speak on it as if it's like, well, you didn't hit him, so it's not assault and battery. And that is generally speaking incorrect. You don't have to.
Can I ask you a question?
Of course.
So you hear all the time spitting on somebody. Is that actually considered assault and battery?
What do you think?
I think so.
It is, right? So let's apply those elements, right? Did that individual engage in an overt act? You spit, right? You spit. Now, did you intend to inflict bodily harm? Can you be bodily harmed from saliva? No. Let's try the other subset, right? Intend to place the victim in fear or apprehension of bodily harm? I would say that there is, I would say that fear, even though it may not be bodily harm, remember, it's harmful or offensive. Is it offensive to be spat upon? Yeah. If someone spits on you, is that offensive? Yes. And is that feeling created if the spit occurs? I think I would argue yes. And there's a lot of case law that would support that. It's a great question, though, because it shows that, again, you don't have to hit this person to be found guilty of assault and battery. And to take it a step further, right? You don't have to physically make harmful or offensive contact. It could be initiated through other means. For example, throwing a drink on the ground and it's splashing all over them. There's another doctrine called the doctrine of transfer intent, which means although you, and I'm summarizing it, there is a more precise definition that can be provided, but ultimately the doctrine of transferred intent proposes that although you did not intend for the offensive contact or act to occur, the intention to conduct the act, generally speaking, while being aware of the possibility of that outcome occurring, transfers the intent from its original point to the ultimate end. So I know, right, that if I throw water, something that splashes on the ground, if you're standing in the direction of where I'm throwing, although I did not intend to throw that liquid at you, I'm also aware that there is a high possibility that it's going to splash and get all over you, right? Like, and that's kind of ultimately what the doctrine of transferred intent's arguing. It's like, look, yeah, you may not have meant this, but you were aware that this was possibly going to happen. You knew that this was a probability. So that's ultimately what it boils down to. But now there's some case law. Again, Virginia, and I want to reiterate this again. This is Virginia. I'm not in any way trying to give legal advice. I'm not in any way trying to establish an attorney-client relationship with anyone. This is just us going over this concept as friends. So when you address criminal and torts elements, a common law concept of assault occurs when an individual engages in an overt act intended to inflict bodily harm, right, and has a present ability to inflict bodily harm, or, and this is where they talk about that subset, engages in an overt act intended to place the individual in fear or apprehension of bodily harm and creates it. But this is the thing that I really want people to understand. They specify in this case, words alone are never sufficient to constitute assault. And I say that and I emphasize it significantly because for me, I've always found that this is a common idea that is believed to be true. You said this, and because you said this, I can respond with whatever action I deem appropriate. That's not true. Words alone are not enough. I could say literally anything to people to a certain degree. There are obviously some exceptions. And there are some instances where those words are taken into consideration during mitigation, which I'll go into later. But that in itself, warlord, is not enough and does not constitute assault, and it doesn't justify assault. What's up, buddy?
I think a lot of people, a lot of people that has real fat necks, but not all of them, and you usually have like half their head shaved, and then like this, and then most of their hair like dyed blue or green. I think a lot of them disagree with you. I think a lot of them always say words can hurt. We should go to jail for words.
Well, it's
I mean,
crazy. No. I get that they may
right,
disagree, but the reason why I love my profession is because you don't have to agree with me. You don't. Like, you genuinely could say Alex is entirely and completely wrong. What I'm arguing isn't based on, it's based on the law. Clark v.
right.
Commonwealth,
Not feelings.
279 Virginia 636. It occurred in 2010. Says words alone are not sufficient to constitute an assault, which means I can say whatever I want to a certain degree, and that doesn't result in an assault, and it doesn't justify instances of self-defense. Warlord, that last part's big too, because I can say you're a piece of blah 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 blah, and you smell like that da 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 da, and all these other horrific things to people.
Hurtful.
They can't say, well, because of that, I am now in fear of harm. Boom. That's not how it works. So, and we're going to get to other concepts, but I love addressing that now, because I think it's something that, just as long as we're aware of it, you're going to hear this. You're going to hear words aren't enough often be brought up in assault. So now, what's up, buddy?
I'm sorry. I'm sorry to sidetrack it. Please don't lose your thought, but it keeps passing through my head. Do you remember your I don't even remember the term for it no more, but your meaning of deadly force
In the military?
Yeah, from what do you call it? From guard mount.
No, I don't.
When we had to remember all the different meanings, I was just wondering because it keeps passing through my head. Oddly enough, I remember it. Anyways,
what is it?
Okay.
What did it say?
Do I really gotta say it?
I don't remember. So you don't. You have to say it if you don't want to.
Force. Deadly force is that force that's used to prevent yourself or others from receiving or causing seriously bodily harm to yourself. Oh, I forgot now. To yourself or others. I forgot, but it keeps passing through my head as you're talking. That's all. Go ahead.
Well, I love stressing that because I think it's something that always gets missed. But the next point that I want to address is a present ability. So, for example, warlord, if I said horrific things to you right now, and you responded by saying, well, you can say whatever you want. I'm balding, nose, whatever. If I punch at my camera, warlord, I punch at the camera right now, and you jump, is that assault and battery? If you jump.
I feel like it is. You just
no, it is
me,
not. No. Now, in all seriousness, I feel like you could argue it satisfies the elements, but really, you got to remember there is a certain aspect of the third element that needs to be addressed. Did I engage in an overt act by punching at the camera? Clearly, obviously. According to the law, they would say that's true. Did I want to place you in fear or apprehension of bodily harm? Yes, of course. You said mean things to me, and I wanted to make you scared, right? But there is no present ability, warlord. Say again?
I said, excuse me, but I feared for my life just now, though.
But see, and I wanted to start. The third element, the reason why this is not assault and battery. The third element is what? There's no present ability, warlord. We are virtually in a conference. You are, Lord knows how many hours away. And as a result of that, no matter how hard I try, you're not getting hit. There's literally no physical way that I could do that. And as a result of that, the law would support the argument that that's not assault and battery. That's me being goofy on camera. That is not this particular offense. So
right.
Now, there is a definition of criminal assault, which I do want to stress because it brings up something that's actually interesting. So it's in Carter v. Commonwealth. A criminal assault was an attempt to commit a battery. Under this definition, it did not matter whether the victim was put in fear or even aware of the assault. Now, this is not the case anymore. you have to see or be a yes. So you have to actually see or be aware of the act conducted by the perpetrator, because it's required in order for you to be placed in a state of fear of harmful or offensive contact. And I think I want to explain it this way, Warlord. If we were face to face, right? If we were face to face, and I did that, I flinched at you. There is a chance that what's up?
Nothing. I'm crying.
Oh, you're pouring water. Got you. So what I was arguing essentially is that if you don't see the act that I tried to commit, how could you be in fear of it?
Others told me that you did it behind my back, and now I'm scared that you're going to come after me and do it for real.
Yeah, but you're so ultimately, what they said is hearsay, and we're going to go into hearsay because it's something I love. But ultimately, you had to be notified of my act by another party, which means you did not observe my act as it occurred. So there was no true way of putting you in fear of harmful or offensive contact. No matter how crazy the gesture was, if you didn't see it, ultimately, that does not constitute assault. So it's a very interesting and peculiar notion for some people, because I could see how others would say, he tried to smack you and he just missed. Like, yes, ultimately. But however, and the most important part of that concept is that we're trying to prevent and protect individuals who are being intimidated or trying to be placed in a state of fear by others, which requires observation of that individual's act. If you don't see it, then to a certain degree it didn't happen, is what arguably would be alleged. So, and that goes into that presentability, right? The fear that people would have only would be because of the ability to actually carry out and commit that harmful or offensive touching, right? Or to be seriously harmed. And I think obviously the virtual example is pretty clear, but you have to be aware ultimately of the act, because it encompasses more than just the injury. It encompasses the whole state of fear, and fear is due to an observed occurrence. So, but to go back into one of the important points, again, words alone are not enough. You get that from Clark v. Commonwealth, and and actually, I want to take a moment. Do you think, Warlord, that word should, depending on, constitute assault and battery?
No.
Because if I'm being brutally honest with myself, like the law says that, and I'm going to turn like, yeah, okay, fine. The law says that's what the law says. I'm not. But the more I think about it, and I will say again, heads up, words will play a part later on as it pertains to mitigation for sentencing, right? So yeah, you may be guilty, but the context of the entire situation as it pertains to why you committed X act will play a factor when it comes to how much time you potentially get, the punishment that you get for the crime. So it's not like words are irrelevant. They do matter. But right. I guess
so if somebody threatened, sorry. I was just saying, so like if somebody threatened, I'm gonna smack you, and then they did smack you, then that's when the words are gonna come into play in court, right?
Well, yeah, but again, based on that scenario, I think you wouldn't be in trouble at all. If he said, I'm gonna smack you, and then smacks you, you're the victim. You're the one who gets to, say whatever. But hypothetically, let's say I'm gonna slap you silly, you walking teddy bear, whatever, something dumb, and you slap me. Now you're guilty all day long, but your attorney will most likely say, Your Honor, Warlord He pleads guilty. He acknowledges his wrongdoing. However, I do want to provide some context as it pertains to what resulted ultimately in this act. See, this particular person, Andre Hamilton, is a very mean person. He said horrific and mean and cruel things to him. He's a bully. He said terrible things about his love for stuffed animals and X, Y, and Z. And the judge may say, okay, that doesn't negate what he did, but it's going to allow for him to say, okay, it's not like he just randomly came up and slapped Andre Hamilton. There was some instigation done by Andre Hamilton that resulted in this act. So words are relevant. But I guess to go back to my question, I don't know. There's times where I think if you say some ridiculousness, I don't know. It does that do words? I mean, you said it. The people with the hair and the shaved, and they say words do hurt, and I don't know, man. I'm inclined to say that.
Also, a lot of the time they're confused about, in my opinion, they're confused about their sexuality, but it's neither here nor there.
Yeah, definitely not here nor there. But what do you think? Well, again, there are, and I think that goes more into the First Amendment. But I mean, we're going to go into provocation and instigators later, so I'll leave it for that. But all right, when it comes to the element 1, engages in an overt act, there's a rule. So, and it goes right into what we're just talking about. An adversary's previous actions form the context in which the adversary's act must put a person in fear of bodily harm. So, what that ultimately means is context is taken into consideration when it pertains to gauging the individual's actions and if they actually do place a person in fear of harmful or offensive contact or serious bodily harm. And they go back to Clark v. Commonwealth, and this scenario, Clark threatens to harm Coleman. Clark threatens to harm Coleman anywhere that he finds her. And that same day, Coleman was trying to exit the school bus, and Clark appears outside the school bus and says, "I'm going to get you." And they're saying that is assault and battery. And they're saying that Clark's previous threat to inflict bodily harm on Coleman, her appearance at the place where she had no reason to be there, her blocking the door, her saying that she's going to get Coleman, and Clark's action of approaching the bus could be understood as indicating a purpose to inflict bodily harm upon Coleman. So, the verbal threat made by Coleman at that time was not assault, but it is evidence of Clark's intent to put her in fear of bodily harm. So therein lies the rub, right? They're acknowledging the words weren't assault, but all this can clearly demonstrate that she wanted her to be in fear, the context. So again, the words aren't enough, but the words do matter. And I think that's really what I want to stress. Words don't constitute assault and battery, but words can show, circumstantially speaking, whether or not you intended to do something. And that, honestly, if I'm being brutally honest, that can apply for many different charges and many different crimes, because mens rea, the intent of an individual, is never truly known. We talked about this earlier on, I want to say. It's all considered through the totality of the circumstances. It is all based on what is observed, the actions carried out on behalf of the individual, the actor. That's what people use to gauge their intent. So now, sheesh. Oh my gosh, the assault and battery is too crazy. So, I say we go right into now the meat of this, and I think one of the meatier parts of assault and battery is the purpose. And I guess what I mean by that is there's a case, Bontovich v. Commonwealth, that says the law upon the subject is intended primarily to protect the sacredness of the person, and secondarily to prevent breaches of the peace. So, generally speaking, again, we don't want to promote aspects of a society that don't respect the personal space of others, right? However, that does not mean that we're going to punish or try to combat incidental contact, right? And I think for me, the prime example of that is Times Square. Every time we see pictures of Times Square, Warlord, it's ridiculous, right? There's so many people walking in so many different directions. People bump shoulders all the time. People bump elbows all the time. Would that constitute assault and battery?
No.
No, right? Because you, by participating in this particular society, you kind of take on and accept that those type of contacts are going to occur if you do try to function and navigate in society. Like, that's just going to happen. There's nothing we can really do to minimize or negate that. But what we do see is that the law is trying to protect the sacredness of people, right? They don't want you running around slapping, popping, poking, touching people without their consent. And I think that the fact that we demonstrate that in the citation in Bonovich shows that the purpose of all laws are taken into consideration when it comes to the actual determination of their violation. Yeah, that sounds a lot of Asians. But, and I kind of said this just now, the intent may often be gathered from the conduct of the aggressor, viewed in the light of the attending circumstances. Circumstantial evidence of intent may include the conduct and statements of the alleged offender. The fact finder may infer that the assailant intends the natural and probable consequences of his actions. That's kind of a meshing of the doctrine of transferred intent as well as the determination of the mens rea of crimes of actors. So, and I guess, Warlord, what do you think matters more when it comes to like intent? What if I said, right? What if I said, I really want to, I'm trying to throw this ball at Warlord, right? If I said that, do you think that that in and of itself would be substantial enough for you to claim that that's my intention? Or would I have to have something else with it?
You said you said you're gonna throw the ball at me?
Yeah. So yeah, let's say you say something to me. Warlord says, Andre, your beard's lopsided, and I say, I'm gonna throw this ball at you. And I grab the ball and I don't do anything else. I just grab the ball. Mm-hmm. Do you know my true intention? Or have I done enough?
No, because I was gonna say no, because you could just be trying to put the fear of, so I don't say whatever it was I said again or something like that. But you didn't actually throw the ball at me yet, so no.
Yeah. But take that same scenario, take away my statement, and add more action. You say, Andre, your beard's lopsided. I say, I pick up the ball, I shake a little bit, I throw it on the ground, and I pick up the ball again. Is that enough? Do you think from those actions you can infer that I want to actually throw the ball at you, or I'm frustrated?
It's enough for me to say you're either frustrated, or it's enough for me to dial 911 and say, I think my friend is about to seizure or he's having some type of issue.
As a defense attorney, I think that's nothing. I think literally that's nothing. Okay, you said something mean about my client. He got angry, threw a ball on the ground, picked it up, and got frustrated with shaking. He didn't throw anything at you. He didn't gesture towards you. He didn't walk towards you. He didn't, he didn't try to swing at you. He didn't do anything directed towards you. You have no right or reason to be in a state of fear or apprehension of anything. So for me, I don't think that's enough. I think that the statement is more damning than just that, even though I did more in this scenario. But I think the statement is what really hurts. My client says, I want to throw this at you. You don't need to see or do anything else. All you need to do now is wait. He said, what? And then you turn and look. I'm holding the ball. That's harder for me to work around. That's hard, in my personal opinion. That's harder for me to navigate. So it's just interesting that intent can be inferred. And we see that although obviously context is important, I think declarations are going to be what determines most. And I think that you can see that in cases, right? That's why statements made by the accused, they come in. There's an exception of hearsay, statements made by opposing party, which results in the statements made by the defendant coming in. So, I mean, it's for a reason. It's because they're very, very important. So, now, touching. There is a definition of the word touching. It's in Parish v. Commonwealth. And it says, a touching, the overt act in the assault falls outside the realm of normal human interaction when it's done with the intent to place the victim in fear or apprehension of bodily harm. When evaluating whether this intent existed, words and prior conduct are highly relevant in shedding light on intent and the context within which certain actions transpired. A perpetrator's intention may be inferred from the nature of the overt act and from surrounding circumstances. The reason why I wanted to read that is because it's because of touching. The overt act in an assault in the case. So that's what constitutes a touching. And I think that it just goes to show a few things. It goes to one, in law, everything's defined. I promise you, everything's defined. Or they refer to the common use of the term in order to bring about its definition. So that, but also, again, we talked about this earlier, normal human interaction. But now Jack Doherty, that's like an influencer, right?
I think so.
Let me Google his name so I say it correctly.
Or is he MMA?
Doherty. Yeah, no, Jack Doherty. He is a YouTuber. Jack Doherty is kind of that little, he's got like a permanent baby face. He has a face that like just doesn't grow up. He just stays. He looks, because how old is he? Like 20? He's in his 20s, but literally
sounds like a first-time on 8.
Yeah, how old is he?
Oh, that's better than the soul, huh?
Huh? He's 20, but looks, yeah, bro. He's 20, but looks like dude just doesn't age. I'm jealous. The guy looks super young. But the reason why I bring him up is because I remember watching videos of him where he would walk big and stuff like that, and he would see someone walk big and bump him. Now, Warlord, we know that normal human interaction falls outside the realm of touching as it pertains to an assault, right? But do you think that he intended to place the individual in fear or apprehension of bodily harm, or do you think that his bumping was a harmful or offensive form of contact?
I mean, yeah, I feel like if somebody wanted to go that far, and if they got the right attorney, yes. But all in all, I believe his intentions was just to try to be funny.
I honestly, brother, I'm going to be real with you. I think it is. I'm going to be honest. Like, there would be times, and you're going to be like, why are you such a nerd? There'd be times where I'd be either just sitting in the bed or, sitting with the missus watching a movie or whatever. And I would think about I think about YouTubers and pranks, and I think to myself, they got to be playing with fire. All it takes, right, is someone to argue that, or all it takes is for someone to extend liability to these YouTubers when their actions or the actual and proximate cause of whatever financial harm that another person takes. I don't know. I'm pretty sure that's probably a law already to a certain degree, but there's a part of me that thinks, how are these YouTube? I feel like these YouTubers are a couple lawsuits away from there being some dangerous case precedent against them, because I feel like this kid, all day long, that is assault.
If I can interrupt real quick, I was saying homeboy in Virginia Beach. He got shot trying to do some prank. Got shot in the gut.
Well, I'm sorry. Did he pass, or is he still alive?
No, he's still alive, and I heard that he went back to the same stupid ways, and then I haven't heard much after that. So maybe he wised up.
Well, I'm glad he's okay, but yeah, man, but I bring that up just because in my mind I think of that normal human interaction. I think that's interesting. So you got the normal human interaction, but if their intent is to create fear or bodily harm, it's gonna be interesting, because I think to myself, again, the rude New Yorker. What if you're an angry, grumpy New Yorker? And I don't mean, I'm not trying to be a regionalist or like anti-New York. I have no problem with the state. Just
Yeah,
let's say this: the rude city person who angry that day, woke up mad at the world, and he walks through and intentionally bumps into people and looks at them all crazy eyed. Is that assault? I wouldn't. Again, man, I'm inclined to say if you could, let's say, the victim says, "Hey, I was walking. I look up and I see this guy who was 40 feet away from me. He gives me a dirty look. He, he goes from walking in a way that wouldn't run into me into walking straight towards me." And I try to walk away like in a different direction. And he changes direction to walk straight towards me. And I try to avoid him. And as we get closer, he kind of shoulder bumps me and keeps walking. In my mind, that's assault battery all day long. All day long. all day long.
Right.
Because even though it is, I would argue, yeah, it's normal human interaction, the bumping of shoulders, but still, his intention was clearly to scare the person. I would say. But okay, so now this is another thing. There's a case law, Lynch v. Commonwealth, that happened in 1921. It says a battery accompanies and includes an assault. So, from that, we now know you need the assault before the battery, right? Right. Battery accompanies and includes an assault, but I would read that as a way of saying the primary is the assault. And I think if you just break it down, you kind of see why, right? Because again, if I try to conduct the overt act, my overt act was intended to create, a fear of serious bodily harm or bodily harm in general, and you were placed in that fear. We have it, but the battery implies contact. So if you don't get hit, but you are still scared and you flinch, that's it all day. So I think I like to bring that up as well because we often do conflate the two. But I kind of wrote the rule of what's up, buddy?
So what if you do a threatening gesture, like you picked up the ball, said you're going to throw that at me and cocked your hand back, and I jumped and I tripped over a Lego and busted my elbow and go to the hospital. What was that?
Let's break it down. I conducted an overt act. I tried to pretend I'm going to throw a ball at you. It placed you in reasonable fear or apprehension of bodily harm. And that was my intention. I would say it's definitely assault. It's definitely, clearly that. Now, I had the ability to do it. It's harmful and offensive. The fact that you tripped over a Lego, fell, and hurt yourself. Deal, what's up? I think that's where we kind of look at causation. I did cause that. But was that like the proximate cause? Was it? I'm going to go out on a limb and say, I would say, yeah. I would say I would probably most likely be responsible for injuries you sustained as a result of me doing that. I would say I'm on the hook. I'm inclined, and this is just a hypothetical. This is just friend to friend. I'm not trying to give legal advice to anyone. I'm not trying to establish an attorney-client relationship with anyone. I'm not trying to lose my job. I got 3 kids and a wife. Please don't. That would be the outcome. They would still get me for it. So I think so. Now
we lost you for a quick second.
Oh, can you hear me now?
Yep.
Okay. So here we go. This is an interesting one. You got Parish v. Commonwealth, Warlord. This is an interesting one. It is true that not every touch is a battery, and every touching is not a battery if it is justified or excused. Now, I mean, that's not a stretch. I mean, I can clearly think of scenarios where that's the case, right? if I'm drowning and Warlord, saves my life and pulls me out of the pool, if he tries to do CPR on me, I can't come to and be like, assault and battery. I can't, right? It's excused. It's justified. He's trying to save someone's life. It kind of reminds me of, you're going to be like, you're such a nerd for bringing this up. But Warlord, you remember when we were kids, the Incredibles movie came out, right? You remember the Incredibles?
I thought we were grown when the Incredibles came out.
I don't think we were. I think we were like teenagers.
You talking about the Pixar movie Incredibles?
Yes, bro. I think it's like
when
I was a teenager. Yeah, Incredibles.
Might have been teenagers.
Bro, it came out in 2004. We were 13, 14.
Whatever.
Well, you were probably old as dirt because in 2004 you were 38, right? Right? You're 39.
Okay.
I'm just saying. I want to make sure that in 2004.
I was in high school.
You were
in high school, sir.
You were You were in the AARP. You were.
Tripping little whippersnappers like you.
So the reason why I bring up the Incredibles is because in the initial scene, Mr. Incredible saves a person's life who tries to unalive himself, and he jumps out the building, and Mr. Incredible, again, I shall outlive my foes. I'm telling you, you guys should Google the scene from The Incredibles. It's that beginning part after Bon Voyage is foiled, right? Or before Bon Voyage is foiled, Mr. Incredible saves a guy's life, and he tries to sue him for that. And I mean, obviously, clear it wouldn't be assault and battery because it's excused or justified. He saved his life. So I love bringing up that example, and it just hit me because, that's a clear example of when because again, let's be real. There was serious bodily harm as a result of Mr. Incredible sprinting, jumping, grabbing this guy, and essentially tackling him through the building windows. The guy was jacked up, but he saved his life. So again, it would not constitute assault and battery. But we do have another instance where words plus action do constitute a battery. It's Lynch v. Commonwealth. The individual grossly insulted her and placed his hand on her shoulder. This was an unlawful touching, and in contemplation of the law, it is considered a battery. I was listening, but I ain't picking up nothing you was putting down. All right, D-Hill. Long story short, brother. This is assault and battery. Real quick, I'm just going to do a real quick rundown. I might become horrible. All right. So when it comes to assault, there's three elements. Engages in an overt act, intends to inflict bodily harm, and has a present sensibility to inflict the harm. There's those three. Or engages in an overt act, intended to place the victim in fear or apprehension of bodily harm and create such fear or apprehension in the victim. And what's Sonny talking about? I want to see. I'm nosy.
I think it originated from if I get flipped out my chair, is that assault and battery?
Yes, it is. So let's break it down. Okay. Was that a overt act? Clearly was. That is definitely an overt act, right? He carried out an act. Was it intended to inflict bodily harm? We got to look at the mens rea, right? We got to look at the circumstances. So unless you were on fire and he was trying to put you out, or unless there was a bunch of bugs covering you and he was trying to get all the bugs off you, there really is no other way to interpret, flipping someone out of a chair. And, I would assume that would create a reasonable fear or apprehension in an individual. So I would argue that definitely and most certainly would be assault and battery. It's something that actually could happen. So that could be a better report. Yes. Then if they actually attack you again, you're justified in whatever you do if they come at you again. So
is the end of that accurate? That's
If
what I was
they
going to
attack
ask
you
you.
again, you are justified in whatever you do if they come at you again. So we're honestly, this is almost perfect timing. We're almost at self-defense, but for the sake of that comment, I'm just going to jump to it. Then I'm going to go back. So self-defense, ladies and gentlemen, people of all ages, this is the most common defense for assault and battery. I will tell it to you all day of the week, every single day of the week. This is it. If you're going to try to counter it, it's usually this. So, common law, a person who reasonably apprehends bodily harm by another is privileged to exercise reasonable force to repel the assault. Gosh, knock on wood. This is the big thing that gets people in trouble. Reasonable force. Reasonable force. Warlord, you are my best friend. This is for you. Reasonable warlord. If I bump you and say, you know, I hate how you stare at me. You can't pistol whip someone for that, warlord. It's got to be reasonable. It's got to be reasonable. The law. This is from different. Oh, y'all, I can read. I'm an attorney. Diffendal v. Commonwealth. Diffendal v. Commonwealth. That's where it says. Now, it says, this is a general rule. A person shall not exercise, or excuse me, a person shall not, except in extreme cases, endanger human life or do great bodily harm. Warlord. Moreover, the amount of force used must be reasonable in relation to the harm threatened. Warlord. It's got to be proportionate. Now, my favorite concept, and you and I talked about this, Castle Doctrine's coming up. And Virginians, I would say this is if I were you, I told the missus after I read this, we staying home. Stay home, because this is gonna get interesting.
In fear for my life.
Say again?
24/7. I'm in fear. I said I'm constantly in fear for my life 24/7. So I feel like I'm always justified in whatever I do because I'm constantly fearing for my life.
Well, Warlord, we will dig deeper into self-defense. I'm just going to take care of this last page, and then we're going to go straight into it. So, and there's going to be something people aren't going to like it. It's coming up. It has to do with parents and children. I'm just going to let you know now. You're not going to like the rule. So, Kelly v. Commonwealth. It is true that a touching is not unlawful if it is excused or justified. We know that. Justification is a lawful or sufficient reason for one's actions or omissions. So, for example, if a police officer is trying to arrest me, that is not assault battery. Sorry, I'm just going to be real. It's not. Now, you get that from Kelly v. Commonwealth. Now, another thing is consent. So, Warlord's my best friend. If he says, Alex, give me some dap, and I slap him on his back kind of hard, but he laughs and says, ha, 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 my best friend. And he slaps me back on the back. Not harmful or offensive because it was consensual. Sorry. Did he answer me? Yes, I did answer you. So yes, that would definitely and totally and completely be an assault battery. Not giving legal advice. This is just me speaking in hypotheticals, me trying to understand the law and testing my knowledge onto fact patterns. So there's that. Now, we're going to go a little bit into justification, then we're going to jump back into self-defense and dig really deep into it. So justifications are defenses that arise from properties or characteristics of acts. Excuses are defenses that arise from properties or characteristics of an individual, of actors. So generally, when it comes to justifications generally provide a right to persons other than the actor to assist or to defend the interests of others because a third party is in the same position as the primary to evaluate the circumstances warranting the conduct. So an example of that would be consent, self-defense, defense of others, defense of property. We're going to go into that, Warlord. Habitation and self-care and the use of force. Excuses, on the other hand, and I call this one the kid defense. So excuses are always personal to the actor. So I really want to break that down because it kind of, as I was reading this, I thought to myself, man, people may not understand this because it goes quick. And what I'm really essentially saying is a justification is not unique to the person carrying out the act. A justification is unique to the scenario or to the situation, right? Self-defense, it doesn't matter who you are or what you are or your limitation, whatever. the situation that is prescribed or identified is what determines if you have that defense. Defense of others, defense of property, use of force, self-help. Those are instances where your actions are justified. Excuse, I want everyone to just think, okay, justification, situation. Excuse, it's you. So, for example, I have 3 children, right? My youngest is 2. My youngest, hoodlum, little wild one, all right? Now, I pick her up, I give her a kiss, right? I love her, it's my baby. She slaps me, straight up, open hand, slap.
That's our Godfather.
That's not right, that's rude. But she goes just, now, is that assault and battery? No, it's not, it's not. Now, why is it not? The reason why it's not ultimately is because it's common law ultimately that individuals below a certain age are incapable of criminal intent. My youngest, hoodlum, but she is incapable of forming the intent necessary, the mens rea necessary to carry out the act of assault and battery. Ultimately, is what they're arguing. So, or what they're suggesting. They also go into certain other instances. So they say, infancy, disability, psychological disorders, other instances where due to that, your actions are excused and they don't constitute assault and battery. Now, this is the rule. I was going to say it. Learned it from her mama. Yeah, haha, Serial. I know who you are. That's rude. So this is the rule. I'm going to be honest with you. This is still up. Oh my gosh, this came out 2022. Oh, people aren't going to like this. All right, Virginia, and again, we're talking through this, Warlord. Virginia permits parents to discipline their children with corporal punishment. This parental privilege excuses what would otherwise be battery in the ordinary course. To fall within this justification, discipline must be reasonable and not excessive. I'm going to leave that there. I'm not going to dig into it, Warlord, because I know that's kind of one of those. That's one of those. So, but I will say, according to the Commonwealth of Virginia, that's fine. The case for that is Woodson v. Commonwealth, 74 VA AP 685 2022. And what I'm reading after by that, when people are like, why does he keep rattling off random numbers and letters? That's the actual case citation. That's how you could find the case. If you wanted to, you could simply put Woodson v. Commonwealth and 74 space VA.APP.685 and then 2022, and you'll find the case that I just read. So
rewind to the video if you have to.
So yeah, if you guys want to, by all means, you can fact check. I'm a firm believer in doing it, but I will say this as a general rule: case law is just kind of like fashion. It comes in and out of style, and I hate saying it that way because people are going to be like, "Oh, why does it even matter?" And I guess what I'm trying to say is there are times when certain cases aren't relied upon as much. And then there are other go-to cases that are just everyone uses this same case. So that is my way of saying, hey, you know what? Sometimes this is the case that is referred to. Sometimes this is the case that's referred to. Sometimes they always rely on Woodson. Sometimes they rely on Taylor v. Commonwealth. So that's what I mean. Now, I don't like talking about it just because, I'm to each their own. I don't judge. Self-defense, though. This is where I love assault and battery defenses. They're kind of wild. My next is coming up, Warlord Castle Doctrine. But all right, let's be real. Here it is. Now, there is no defense for this situation that I'm about to describe. I hope everyone heard me. I hope everyone heard me. A defendant accused of a crime cannot avail himself to self-defense where he himself was the aggressor and brought on the necessity for the assault made. Did everyone hear that? Because for me, that is big. There's going to be another situation where they build on this. But ultimately, the long and short is this. If you're the aggressor, if you're the instigator, you get no defense. Off the rip. I want everyone to understand that. And the reason why I want you to understand it is because ultimately, it will usually be other witnesses that determine who, in fact, is the instigator. So I will say it again there, Serial. A defendant accused of this crime cannot avail himself of a plea of self-defense where he himself was the aggressor and brought on the necessity for the assault made. Having provoked the difficulty, it makes no difference what prior threats were made by the party assaulted. And that was from Lamb v. Commonwealth. Another way of putting
Put
it
it in
was a
English
sin.
real quick.
sorry, D.
Put it in English real quick. I'm sure he understands, but just put it in
No. So this is I want to apologize because thank you, Serial. The reason why I want to apologize because I speak legalese and I do apologize. Hey, there it is. I shall outlive my foes. Boiled it down perfect. If you're the aggressor, if you're the instigator, you don't get self-defense. Boom. You started, you don't get self-defense. Now, is that true all the time? No, it is not true all the time. I'm going to give you an example of when it's not true. But if you started, you don't get self-defense as a general rule. That's funny.
What's considered starting it though? What's considered starting though? The first person to get physical, or could it be the person that got into my personal bubble, yelling in my face, so I smacked across the face with my pillow? No, we won't say that. So I pushed him out of my personal bubble.
You just answered it. First things first. Is that reasonable force, Warlord? It's not. You'd be the instigator. Now, two. Context matters, right? And we talked about how mere words aren't enough, but mere words do allow for context to be established. Also, the totality of the circumstances will usually be what determines if an individual is an instigator or not. For example, me and Warlord are out. Warlord sees someone leaning on his car, sitting, leaning up against his car. If Warlord says, "Hey,
by the top button."
Don't lean on my car. And this person becomes super aggressive. Hey, what the bleep you gonna do about it? Bleep. Instigator is obviously that individual, right? He would be. Now, he's the instigator insofar as he's being super confrontational. Now, if Warlord slaps him for that, who's the instigator?
He is.
You're the instigator.
Okay.
Because mere words are not enough. Words are not enough to justify or constitute an assault. You can't self-defend that. You cannot defend yourself if he just says a bunch of words.
Let me ask you
this.
Do
threats count as starting it? So we're going right back to it. They don't. Bleep. I'm sorry, y'all. But yeah, again, words are not enough. Words do not justify the use of self-defense.
I've been in more than one fights where someone's close enough to me that a little spitlet bubble from their mouth landed on me, so I popped them across their mouth. Never been arrested in any of those, but I'm saying, does that count?
Okay. Nobody wants to understand. Again, this is hypothetical. I'm not providing legal advice. I am not trying to establish an attorney-client privilege with anyone. This is just me talking to one of my best friends, probably my only best friend, because I no new friends. No. So now. So I'm in a dispute with another individual. We get into each other's faces. I say something and spittle lands on his face. Is that an overt act? Is that an overt act? I think it doesn't make it past the first element. If we're going to be brutally honest, I don't think it does. Is that an overt act?
I feel like
no.
For it to happen.
It does. I don't think it. If you intended to spit on me, that's one thing. But if I'm just talking and spittle lands on you, is that an overt act? No. So if you defend it, if you try to defend yourself, that would constitute you being the aggressor, and that would result in you not being able to use the defense, and they would be able to defend themselves.
Okay.
D Hill.
So I
no, you're not Gucci. You're not Gucci. You're not Gucci. Y'all, people, wow. All right. Now, Warlord, I don't got much time left. We're going to go over a few more things, and then we're going to wrap this up. I'm going to talk about probably one of the most important doctrines, in all seriousness, This is one of the most important doctrines in Virginia. So, Hines v. Commonwealth, right? When a party assaults a homeowner in his own home, the homeowner has the right to use whatever force necessary to repel the aggressor. Did everyone hear that?
What I heard is if they're trying to get out of my house, pop them in the legs, then the back, and drive back in my crib. And flip them over.
I didn't hear what you said on that one. I'll reread it. When a party assaults a homeowner in his own home, the homeowner has the right to use whatever force necessary to repel the aggressor. Defense of the castle doctrine provides that a man is not obliged to retreat if assaulted in his dwelling, but may use such means as are absolutely necessary to repel the assailant, even to the taking of life. Hines v. Commonwealth, 292, Virginia, VA 674, 2016. That is the castle doctrine. It's in Virginia. That's big, folks. I think that is the reason why you should tell all people who ever think about doing some tomfoolery. You shouldn't do it in Virginia. You should never do it in Virginia. Pick a different state. Please. Because this will be the reason why you get buried early. Again, it is a very strong.
You're from here, don't come here, boy.
But I really want to stress something. I'm a firm believer, and my wife says this all the time. Don't lose the detail, because for me, I think, and she's right by emphasizing this, a party assaults a homeowner in his own home. That is very, very restrictive, right? Very restrictive, because that means if he's outside, I mean, you know what I mean? Like you got to be careful with this. I will say that up front. I will also say that Hines v. Commonwealth is a very, very significant case. It's very impactful. So I will be the first one to say again, I'm not your attorney. I am not trying to be your attorney. This is not attorney-client privilege. I'm not trying to establish a relationship. I got 3 kids with a wife. Please don't get me fired. But look into that case and ask an attorney in your area. If you don't live in Virginia, see if castle doctrine, is something that exists in your state. If you are a Virginia native, dig into the case yourself. Warlord, you're my best friend, so we'll obviously talk about this off camera. But yeah, man, that's a wild case. So, but I think D Hill brought up this next thing.
You was welcome to try to break into my crib.
Warlord.
I'm gonna have the lotion, the guns, the handcuffs, all of it ready for him. The knives.
How many bottles of oil did Diddy have?
Yeah.
How many bottles of oil did Diddy have? 1,000 bottles of oil is crazy. That is crazy. Diddy is crazy. Bob Business said 1,000 bottles of oil is wild.
Oh man, I can't breathe.
But it's when you're drugged and you're not.
Okay, we're done talking about that. I'm just trying to say 1,000 bottles of oil is bananas. All right, but that is bananas. But all right. I believe someone in the comment section brought up instances where you may have been an instigator or the aggressor, but you stopped. So whoever did it, hey, points for you. You get bonus points. And when we do misdemeanor or felony, you start with the lead, because that's called the imperfect self-defense. And really what that means is the law will excuse certain acts of self-defense, but this is a hard standard to satisfy. So if you were at fault initially, you were the aggressor, but you abandoned the conflict in good faith and you retreat, you will be excused to use self-defense if the prior victim becomes the aggressor. So I know that sounds long-winded, so I'll dumb that down. Ultimately, what that means is if you bully or if you try to push the situation, but then you stop and you try to withdraw and they come at you, you're green light. That's fine. But you guys got to hear again, she's right. Attention to details. What is the biggest detail that I think you will get messed up? you have to abandon in good faith and retreat. So it's not just, hey, yo, I'm cool. You have to genuinely, in good faith, retreat and withdraw from the situation. And then when they continue on, you're good. You're green. That's fine. But I really want to stress that because that'll be the first thing that will prevent that as well. So don't be an aggressor. And if you are going to be an aggressor, you got to totally and completely withdraw and retreat in good faith. You have to show it. But at the same time, that good faith is what? What is that? I would argue that that's another instance of mens rea. So that has to be gauged in the totality of the
a matter of
circumstance.
speed.
Well, I mean that too, but yeah.
Like,
I
mean, if somebody doesn't give you the chance to retreat because you broke into their crib, I mean, that it is what it is.
So you got an example in Bailey v. Oh, sheesh. Ironically, it's Bailey v. Commonwealth. This happened in 1958. This case is Bailey v. Commonwealth. That's hilarious. So this individual was attacked. He was at fault initially. He withdrew. He was attacked as he was withdrawing. He announced his desire to not fight and continued to retreat. The victim turned aggressor continued to attack, and then he ultimately unalived the aggressor. And that was considered to be a good to go. That was good to go. What's up, God Body? So that's Bailey v. Commonwealth 200 VA 92. So that's just I want to stress that. So you have to, and Harper v. Commonwealth also spells it out. If you provoke, you have to, in good faith, announce your desire for peace, and you have to withdraw. That's how you are open to this potential imperfect self-defense. I know we don't have much time left, so I'm going to say again.
Girls, be quiet.
So what if I didn't hear them? What if my adrenaline is pumping so much, I'm hearing my heart pump in my ears because I realized somebody broke into my crib, and they said, "Oh, my bad. I ain't gonna break in. I'm gonna start walking out your crib." I ain't hear that, and I popped them up. Well, I mean, I guess they would have no way to prove it unless somehow your ring caught it, or you got cameras on inside of the crib.
Girls.
If you did, you can't defend yourself.
I will let those individuals in the chat, as well as everyone who is watching, make their determination in the comment section below. I am neither going to comment on that nor provide my opinion because I got 3 kids and a wife, and I'm not trying to get fired. So, defense of personal property. This is actually a good one. Defense of personal property. Rule. The general rule is a man may rightfully use as much force as is necessary for the protection of his person and property, but he shall not endanger human life or do great bodily harm. I called it the warlord rule. I wrote warlord rule. Just being honest with you. So I'll read it again because I'm going to read it again because you're my friend. A man may rightfully use as much force as is necessary for the protection of his person and property, but he shall not, except in extreme cases, endanger human life or do great bodily harm. You get that from Commonwealth Alexander.
Not too much.
Huh?
That's just, so basically I'm hearing that the handcuffs, oils, and lotions is not too much. And if I lock them in the basement for a few days, bro, if you break in here, it's like you get what you get. You know what I'm saying?
I need to listen to more Diddy songs so I can quote one. I haven't listened to him in so long. I couldn't even say any. I couldn't think of any. I've been around. No, I just can't think of any Diddy songs. I need to have one in the pocket. I need to think of one so I can just drop it randomly. So warlord, this is another. I wrote warlord rule twice. Oh, here in Brazil, a guy fell through an old lady's ceiling window and fell on a knife. He sued her and won. That is crazy. That is wild.
That is crazy.
Isn't that, I heard about that in a movie too, in Liar Liar. They brought that up.
Why?
That is
Warlord, your other rule that I wrote about you, Commonwealth v. Alexander, a deadly weapon may not be brandished solely in defense of personal property.
nah, bro. You steal my wallet. That's it.
The threat to use deadly force by brandishing a deadly weapon has long been considered an assault.
So if I hold it underneath my shirt and pop them, I didn't brandish it. It was under my shirt. They couldn't see it.
So you know what? Actually, sorry. I think we should do a brandishing episode. I want to, because I've won that case a few times. I've won that 3 or 4 times. Brandishing's fun.
Oh, what?
I think one of the more recent cases I won of brandishing was based solely on the complaining witness didn't actually have sight of the firearm. He heard a gun sound, the cocking allegedly of a shotgun, and that's all he heard. And I beat it because I argued that you couldn't be in fear. I pretty much argued the assault defensive. You can't be in fear of something that you do not actually see. And I used case law that pretty much described brandishing as like a super flamboyant essentially gesture. So but yeah, defense of real property, can't brandish a weapon. You can only use force necessary. You can't endanger human life or bodily harm. We don't have much time left, so I'm going to wrap this up. You cannot use firearms to defend your property, your land. There is a concept that I really wanted to address. What's up, buddy?
You can't use
Yeah,
firearms.
exactly. Your comments are wild. Nobody needs to be greased up. Exactly. Good Lord. But yeah, actually, I will spend a little bit of time on this, and we'll call it a day. So, defense of others. Defense of others is a very interesting defense because ultimately, what you're alleging is that you are utilizing a defense that the complaining witness is also open to utilize. So, example is if you, warlord, saw me getting stomped out, and you then decided to go crazy on them, and they said, "Hey, we're going to sue warlord for assault and battery." You're essentially saying, "No. Andre Hamilton has a right to self-defense, and as a result of that, I too have a right to self-defense because I am asserting his defense." A person asserting a claim of defense of others may do so only where the person to whom he aids, he or she would have been legally entitled to defend himself. So, hey, warlord was defending Andre Hamilton. Andre was just walking down the street and got stomped out by, a couple ninjas. Like that, I am entitled to a defense. I wasn't an aggressor. And because of that, you helping me would totally be, you'd be protected by defense of others. However, again, the missus is right. Attention to detail. What does it say? You would only be entitled to this defense if the person who you're defending was also legally entitled to it. So if I was the aggressor warlord, I was slapping up a couple ninjas and they get the better of it, you can't then jump in to help me because I was the aggressor. So again, this is always say again.
On the dead home, I have to though, or else I can never show my face again.
Okay, well, believe me, if you defended me, I'd appreciate it, buddy. But having said that, we're getting close to the end. So I say let's spend our last little bit on the best mutual combat. We're gonna end it on this. Yeah, that is true, Godbody. You will catch a lawsuit faster than you can catch the bouquet in America because people are quick to sue. I love criminal. That's why I kind of am not a big fan of that. I got sued over self-defense and lost twice. Fam. Well, before we go into mutual combat, I want to actually bring that up, Godbody. You got me really thinking. So I really want to stress this. Please be aware, everyone. that there is a difference between criminal and civil. There's two different standards, and although you may be found not guilty for something criminally, you can still be found liable and then be pursued in a civil matter. Again, I'll let you guys. I'm not trying to provide legal advice. I'm not trying to establish an attorney-client relationship with anyone. I got 3 kids and a wife. Don't get me fired. But yeah, I want you. I would strongly urge people to seek out legal counsel so they can get the gist of what I said. Ultimately, you could be found not guilty of assault and still be found financially liable for the injury sustained. So I would definitely look into that. But yeah, before we wrap this up, mutual combat. Say again?
I was just saying that's good to note. Good keeping your mental note.
Yeah. So we're going to go over mutual combat, then I'm going to call it a day. So mutual combat. I love mutual combat. It's such a fun argument to make. It's hard, but it's fun. So for combat to be mutual, it must have been voluntary and mutually entered into by both or all parties to the affray. Let me say that again. For combat to be mutual, it must have been voluntary and entered into mutually by both parties involved. So an example of this that I had one case where a guy had 3 different mothers. He had 3 children from 3 different women, right? Now, he was going to pick up one of his children from a baby mom 1, and he was being accompanied by baby mom 2. Baby mom 1 and 2 saw each other, and they were saying very crazy things to each other. Baby mom 1 said, "Come see me anytime, anywhere." Right? Baby mom 2 said, "We got right now if you're really about it." And baby mom 1 says, "Say less." They both popped out. They both put the kids down. Baby mom 2 put kid in car. Baby mom 1 put kid back in the house with older kid. And they met and were throwing them, right? Well, baby mom 2 took an L. It was a bad L. It was not great. The footage was wild. But she then tried to hit baby mom 1 with assault and battery. And sorry, Mimi. And this was where, although the court didn't necessarily agree with my interpretation of this case law, baby mom 2 was found, or baby mom 1 was found not guilty. Why? Because although she says that this is an inappropriate application of it, I argued clearly she challenged baby mom 2. Baby mom 2 said down. They both came and met on that yard. They both mutually put them up, and they both mutually were letting it go. Now, this is an interesting point. Harper v. Commonwealth talks about this. A fight versus self-defense is different, right? Mutual combat versus self-defense is different. Why is it different? It's, again, attention to detail. Mutually entered into, right? Mutually entered into. If baby mom 1 said to baby mom 2, "Hey, come see me," baby mom 2 was like, nah, I'm cool. And baby mom 1 went after her. Baby mom 2 has the right to self-defense, right? Like all day long. Mm-hmm. We just read that. The instigator would have been the first baby mother, and she would have been charged with assault and battery. But I would argue it is only the affirmation of baby mom 2 who says, "Yeah, let's go, come see me," right? That's where mutual combat is established. Voluntary, they both come together and say, "Let's go," right? MMA, it's on. Like, that's when, Bruce Buffer at that point. But the moment that one does not, or the moment that one is forced to fight because, jumping, or because one starts throwing without the other's acknowledgement or mutual agreement of the fight, self-defense is there, and you're the instigator. And then what do you need to do in order to get that imperfect self-defense? You have to in good faith retreat. You have to announce it, and you have to actually withdraw.
I was going to say, when you say, what if she says, stop, no, never mind.
Then see, that is significant other. I was going to say significant other. So Mrs. Hamilton said, well, Mr. Ham said, gosh. Well, if what happens if mutual combat turns into, one person saying done, right? If one person says done, what happens then? I would argue you get 2 scenarios. Mutual combat, person A, person B. Person A fights, person B says, I'm done. If person A stops, It's done. It's fine. There is no problem, right? If person A does not stop, what do you have right there? What is that? That is assault and battery. That is, by definition, a clear assault and battery. So I would say that is, and again, attention to detail. It's stuff like that that'll get people that'll get someone to catch a charge. So I want to say this. I always say it, and I genuinely mean it. Warlord, I appreciate this, man. I love this. I love the law. I love going over it with my friends and family. I love talking to all you guys. This is fun. I enjoy this. I went over this because one, obviously, this is my job, but two, I love this. I like to give people tools to protect themselves. In all seriousness, this is fun to me. So I appreciate this. And if you guys have any questions or comments, please, leave a comment in the comment section, and Warlord and I will get to it. If you want to email questions or comments, I'll send Warlord, the email, and we can do that. If you guys want to recommend topics or fields of law that you want me to pick, obviously, please, criminal. I don't want to do that stuff. If you guys want to pick something crazier, we can do it. I was going to do a few fun ones. I had two. So before we leave, I'm going to talk about them real quick, and then you guys can tell me what you think. So, don't laugh. I know you guys are going to probably be like, "Yo, this goofball. Why do you pick these?" But I thought these are interesting. So I'm working my way through harassment by computer. Now, why am I working my way through that? Because if we're going to be brutally honest, it's 2024. This happens more than you think. I literally, as I'm reading this, I think to myself, everyone can catch this charge. Like, honestly, if I was trying to be funny, if I could get $1 for every time I can convict someone of this charge, Warlord and I would be legit rolling in it, because this is so easy. It's so easy. Yeah. Harassment by computer is one that we could go over if you guys want to. Now, lastly, and you guys are going to think I'm a goofball, but I just think this is hilarious. Indecent exposure. We don't have to go over it, but hey, it's 2024. People are crazy, and I think this is also hilarious. As I was reading this one, I thought to myself, this would be too funny. I think it'd be a bunch of Diddy jokes, but it could be done, and I think it's still an important law to learn. I'm a firm believer that we should probably hit harassment by computer, because this is literally life. Like, how many were you? I mean, right now, man, like, this is very important. So, again, you guys, please go out there, leave a comment. If there's a topic you want us to hit, by all means, please let us do it. Or please tell us, and I'll definitely do it. And Warlord, I appreciate you, man, wholeheartedly. This is fun for me, and I appreciate the opportunity. The missus is awesome for letting me do this, and I think deep down she wants me to do this because she knows, one, I always wanted to teach, and two, she knows
You
this
leave
is
me alone.
There you go.
Yeah, I guess that. So yeah, man. I do appreciate it, brother. Nothing but love and respect for you. Thank you. And yeah, man. The next time, you guys take care.
Well, I appreciate you taking time to do this.
Later, buddy.
Wait, you should ask.
Peace out.
Wait, what?
The topics for next time too.
Yeah, so that's what I'm saying. So if you want, I think we should do harassment by computer. But if you guys, Warlord, make a poll, I'm totally fine with whatever, man. I love doing this. I will say, I have a jury trial next Tuesday. So, if you want to do the poll, I would say ideally do it like, tomorrow or Saturday, so I know which field of law to prep for, so we can get it done, so I can get it prepped for the episode. Because Monday and Tuesday I'm going to be super busy, man. The jury trial is probably going to last all day. It's going to take a while. So again,
give me a few topics, and I will make a poll, and I will get to you when I can.
Okay. No. Yeah. Hey, you know what? Unauthorized concealment of a firearm would be a good law. I've won that case a few times too. Those are always fun cases. Unauthorized concealment of a firearm is good. So I'll text Warlord again. You guys tell me what you think. Leave comments. If you guys find something that's good, let Warlord know, and it'll definitely make it on the list. But again, I appreciate you all. You guys are all awesome. Again, the law's important. And I think once more people realize that, the safer we can be, because then at least people know, what they're looking at. So you guys take care, brother. Take care, my friend. And I'll see you guys later. Take care, man.
All right, bro. Like always, we appreciate y'all. Hit the like. If you're subscribed, hit the subscribe. And once again, we decided, Andre and I decided, every 100 milestone, I guess, is a incentive and a thank you. We'll do little money raffles up to, I don't know, 1,000, I guess, up to 1,000 subscribers every 100. Appreciate y'all. Y'all have a good night.